Welcome to Digital Davos. My name is Professor James Cooper from California Western School of Law. I'm here in San Diego, and we've got panelists from all around the world and from different perspectives, and welcome to everyone. We're still waiting on one other panelist, but we're going to go forward. And just wanted to start, Karen, with you. Brazil has been such a pioneer on so many levels in the digital world, but still has a problem with piracy. Will Latin America always be, and maybe Brazil specifically, will always be a net importer of technology? Or do you see, as we look at the future of IP, which is what this panel is about, do you see a changing shift as the global South makes its mark?
Well, I see a changing shift, yes. We have many challenges for the traditional intellectual property protection as such in this virtual world, but I think Brazil is very much attuned to new technologies, to internet and the web, and I think IP is developing in certain ways, maybe indirectly also through other legislations that rule the use of internet, privacy, and so on. I think IP as such in the world has this challenge of being sometimes when industrial property is involved, now a locally granted right with global effects. So this is something that maybe WIPO and other associations and we selves have to think about. In terms of policies, I think now with the new government, we will have, again, a good focus on innovation, on research and development. I'm hoping so, that this is rescued somehow. In terms of legislation, we are attuned to the latest developments. So I see good news coming from Brazil.
Wonderful. Guy, how about what's happening in Asia? You're doing a ton of licensing. Where's the growth coming from? And then second part of the question is, the People's Republic of China is super gung-ho about IP rights now, which is kind of reversed what has been decades of the other way around, the pirate or copier nation. Now they are leading with SIPO, the state intellectual property organizations. Numbers of filings have for a decade surpassed all our countries combined. Certainly the EU, the US, China, Japan, and Korea. What's happening in Asia, and is the PRC really driving it, please?
Sure. Thank you for the introduction earlier, and I'm happy to be here. The changes in if you want to call it the East, are no more prevalent than when you take a look at the USPTO patent grants last year, as Samsung supplanted IBM that had been the leader for years. And if you look at the top 10 grantees last year at the USPTO, 6 out of those 10 were Asian headquartered companies. So there's been a shift over the last decade and a half of the patent filings, not only in the PRC, but also at all IPO offices around the world by Asia-based companies. And with this has come an increase with licensing. I think we're involved in licensing conversations every week, and it's always with an Asian-based company, with maybe a company that's located overseas in the US, or we even have a few companies in Singapore here that have been doing some extensive licensing. So we're going to see more and more licensing, and this has been a process that's been ongoing for a number of years. It's been driven by patent grants and patent filings to begin with, and now with some of these companies having very large patent portfolios, Samsung, Huawei, and you may have noticed that Huawei has had well over $1 billion in licensing in the 5G space over the last couple of years. I think we're going to see more and more Asia-based companies continue to license their portfolios and look for opportunities to get a return on some of the R&D that they've done and really participate in the licensing activities that have been going on in the West for decades. So I expect to see that to continue. And if the trend continues the way it is, I think you're going to see all top 10 companies, US patent grantees, will be Asia-based companies if the right things are going.
Thank you for that, Guy. JP, you worked for years with Samsung. You've been a lawyer for so many of these multinationals, doing IP work now, Vice President of Qualcomm. What's your view of the future of IP in general, and about whether it's going to be region specific? Is it going to come from Asia specifically?
Hi, Jamie. Hey, thank you for the invitation to the panel, and I'm happy to be here with Guy and Karen and you. Yeah, I've been very lucky. I've been working at Samsung and Qualcomm, so I had this firsthand view of the role of IP And from innovators like Qualcomm, where they invest money into technology 10, 20 years in advance, taking the risk. And then now you have the IP being standards, where you're opening up. Traditionally, IP patents been something that you exclude others, but through standardization and licensing, you see the technologies opening up, and you see the innovation by Qualcomm, and then the implementers like Samsung taking the technologies from 3G, 4G, and now 5G, and the smartphones that we use every day. And I joined Samsung in 2010 when they first came out with Galaxy One, and the success of the Galaxy, the Android phones, but also on TVs and other consumer electronics. Aside that, as Guy has mentioned, you see this role of being international IP. And so you see the growth of the role of IP in not only the US, which has been traditionally US, and I'm educated in the US, so that's what I was focused on. But now you see the European countries, Unified Patent Court in Europe, the Chinese courts. So I see the future of IP just playing bigger and bigger role.
Thank you for that, JP. And for those of you who are just joining us, we're at Davos, Digital Davos 2023. This is a panel called The Future of Intellectual Property. We're here with Guy Pollux, with Karen Clem-Franco and JP Hong from Qualcomm, and we're talking again about the future of IP. Karen, as you've expanded your own career, both as an academician and as a partner at a law firm doing IP work, are you seeing more and more of your clients moving into the metaverse and other kinds of disruptive technologies? And how is intellectual property changing because of that shift to Web 3.0, even in the context of AI, please?
Well, here in Brazil, I see a little bit of resistance still with metaverse. And what are the consequences of entering the business into this environment, and also changes related to artificial AI and consequences of development of AI, privacy issues related thereto, and lack of control over the training of the machines. And I see things developing, but in a very slow pace regarding metaverse. I think it's a big challenge for everybody that deals with IP, because again, if the web was already a challenge for IP in terms of enforcement and so on, I think the metaverse as such is a completely new way of thinking IP rights, right? If you go to the classification of trademarks, what kind of class do you use to be in the metaverse, right? To protect your trademark. And does it make sense to have a local registration involving this activity in the metaverse at all, right? So, and this change of leaving everything, this tendency of leaving everything to the protection of copyrights, I don't see it as well as something very strong in terms of IP protection, right? Because the copyright protection has its faults, but that's how people are dealing with.
No, thank you for that, Karen. You know, people talk about interoperability. I always say, what about legal interoperability? Let's as comparative lawyers or as international lawyers, how can we develop systems that can move across from the common law to the civil law, or to the law in the PRC with scientific socialism, or Sharia, or the Halakha, or indigenous rights? Because everyone's going to participate in the metaverse eventually, and hopefully so that it's accessible. How do we get that legal interoperability? Now, Guy, you were way ahead of the curve. 2004, founding the first, now CEO and chairman, the first full service IP company that's based in Asia. You've seen a whole lot of growth of what, as you explained earlier, has been a more heavy penchant towards IP. What about Web 3.0? Is that where we're going to see a ton of growth going forward in terms of IP development and some licensing the brands and so forth?
You know, I think a lot of this, the judgment's still out there. We don't know what's going to happen. You know, at least in the patent space, you know, artificial intelligence, machine learning. We had some patents that were filed. It was actually, I think it was over a year, maybe a year or two ago, The invention was developed by an AI bot, basically, that came up with some things. The Federal Circuit ruled last year that was not eligible for patenting. And I think we're gonna challenge things like that. I think there's going to be a look at the patent law and say, listen, how can we come up with ways to protect some of this new content that's being created or new inventions that are being created? And I think what's really interesting is when you get to individual content creators today and how they're playing out on different social platforms and all the other things. How do you protect that, and how do you get a license stream going on that and collect it and maybe even securitize it? These are all things that are in the works. We've seen a lot of things come up and be tried, and people are working at trying to make new revenue streams out of them. I don't think there's been a 100% success on anything yet, and so a lot of it is still in progress, and we'll just have to see how it plays out.
No, that makes a great sense, because we're still waiting to see whether this is obviously fully adopted. JP, before I ask a question about the future of IP rights, I want to do something exciting, and we're calling it the lightning round, where everybody gives a yes, no, and you're all sophisticated people. For example, Guy's been a naval officer in the U.S. Navy, has a degree in nuclear engineering. So here's the statement, and agree or disagree. Say yes or no. I read the user agreement when I install the software. JP, you first. Do you read it?
Personally, no.
Okay, thank you for that. We're coming back to you about the future of IP. Guy, do you read it?
No, unless it's a very expensive software package.
Thank you for your candor and your honesty. Karen, a PhD and a bunch of stuff, and renowned intellectual property expert. Do you read the user agreement when you install the software?
I always read. I am really the one.
We have a winner. We get to do the wave for you. Is everybody ready? We're gonna do a wave. Are you ready? 1, 2, 3, wave.
But
all right.
I don't like the agreement, but I installed the software anyhow.
Oh, you still install it. Okay, you read it, but you still agree to it. All right. Thank you for that.
Do you redline the agreements too?
With lots of red lines, absolutely. Now that we have a good sense of who's doing what, in terms of due diligence on their own personal computers, JP, where's the future? Karen talked about that copyright's not going to be able to handle all of this. Where do you see IP developing, and maybe there'll be new categories, do you think?
I think the IP rights, the patent rights will continue to be play a very important role. And I just want to go back to an example, and I think all of us here remember back maybe 20 years ago when we had cell phones. But when you have a cell phone in US, and you try to take that to Brazil or Korea, it just wouldn't work, and you had to change. But now with the standards and with the IP role that has played, you can take your phone, your iPhone or Samsung Galaxy phone in US, take the 12-15 hour flight, and it would still work in Korea. To me, that's amazing. I mean, still to me, it's just amazing that you don't have to do anything. You just turn it off from airplane mode and you turn it on. The future, like people have mentioned, the AR, VR, but what we see right now, the technology we're using right now for this conference, the video codecs that we're using, that's also the people have invested in that. Qualcomm have invested in that, and innovation, and now everyone's using it. You see this in videos and TikToks and Netflix, and some of this will be continue to be used in the AR, VR, metaverse. And it just, if you think about it a little bit, it is amazing. Jamie, you can take a short video of yourself or what you're doing on your iPhone, you send it over the internet. I may have a Samsung phone, I may have Samsung TV or LG TV or a computer laptop, and it all works. And again, to me, 10, 20 years ago, it did not work like that, right? But now it's interoperable. And again, I believe this is the IP role playing along with the innovation and technology and people implementing everything coming together.
No, I think that's, I'm going to go just a little off script in terms of my questions, because you hit us with something about interoperability, everything harmonized and standardized. But like you said, it wasn't so long ago that we were fighting, GSM versus CDMA or Crest versus Colgate in the toothpaste world. But now we're in a world of our 5G and the 5G of the People's Republic of China, or our AI and their AI, so we're seeing, are you all, and let me ask each of you, are you seeing a kind of decoupling? And for those of you in countries other than the US and China, Are your governments being asked to make a decision about whose tech future in the world of tech nationalism that you're going to have to follow? Karen, do you want to start?
No, I just want to come back a little bit and bring a topic that I thought was very important in terms of enforcement of IP rights. What I'm seeing as a tendency is when we are in environments that are subject to contractual agreement, we can enforce other kinds of dispute resolution, adequate dispute resolution methods like mediation, conciliation, even arbitration. And I think this will be the future for enforcement of IP in such environments. I would like to pass the word to the others and then I'll comment on this again.
Thank you. How about you, Guy? Are we seeing a kind of decoupling?
I'm not sure if it's a decoupling. The one thing that I'll kind of build on with JP, it's not just how everything works together now. It's how so much technology gets packed into smaller devices. You know, the phones back 20 years ago would be, maybe 1,000 patents read on those things. Then they became 10,000 patents. And now the amount of technology that's being combined into your devices and how that affects licensing and how you can actually not so much decouple, but you can actually make decisions where you're adopting technology, but it ends up adopting a whole group of technologies in. So I think it's almost easier for governments to sit down and say, we were going to go GSM versus CDMA, and now they can just kind of pick it and they get it all, right? Because it can all be packaged together. And I think makes it much easier, I think, at that level. On the licensing side, it gets a little more challenging, but that's just the way the world is moving, I think.
JP, how about you? What's your sense?
Yeah, I don't think so. I mean, I think there's certain forces maybe, but I mean, look, if my phone stopped working, if I travel to Korea, I won't be happy, right? And I think people have seen how when it's interoperable and multinational and things work smoothly, no matter where you are. And if I try to send video clips to my friends in France or Europe, and if it doesn't work, I think people will complain and be very unhappy. So I think people have seen how the international, the technologies working together, how great it is. And I don't do TikTok, but I understand you can share videos and watch videos of people in other countries. And I think people enjoy that. And in the legal front, you do have the courts in Europe and you have courts in the US and you have the courts in China, and then Karen referred to the enforcement. So there is a little bit of I wouldn't say lack of synchronization, but you do have they're on their own. The courts in Europe, courts in the US and in Asia, and they'll do what's best for them. But I think for the consumers, for people like us, the multinational, the technologies being worldwide, interoperable, I think that's very important, and I don't think that's going away.
Yeah.
Thank you for that. Karen, did you want to add to that in terms of
Yes.
either a decoupling or a sense of how we're managing this at a geopolitical level?
Yes, I think this will be more something of agreement between the private parties, and then this will be brought as a package to the governments for approval, as I was telling and also JP. Instead of choosing between this or that technology, what I see is an effort to have your technology at all chosen, because if you don't have interoperability, there is no sense in developing this technology because it will not be used at all. So I think this private agreement and this cooperation will be the future for including everybody and maybe disrupting a little bit this IP in a certain way, but then we will have the friend rules for the licensing and so on.
You raise several great points, but the one earlier about mediation and arbitration, because not every piece of litigation could be like what JP and some of the companies you've been involved with, in terms of the hundreds of millions of dollars of legal fees and the huge patent issues that are being litigated over. A lot of it is smaller stuff. And are we doing enough to encourage our law students, or our students or engineering students, to understand that not every problem has to end in litigation, not every dispute has to be in a cutthroat court of law, that we can settle these things? What are we doing to help educate the consumer and our future lawyers and engineers to be able to handle this world of conciliation and non-litigious activity, and what more can we do? So Guy, you're the non-lawyer in the group, but with the engineering degree, did you learn any of this stuff in school, and do you think they're doing the right things now?
I'm not sure that they are, and I know I didn't learn those types of things in school. You kind of look at the engineering side and what can you do, what can you design, what can you design around, those types of things. I think that's an interesting topic. We're involved in a fair number of litigations, and I think a lot of it depends upon the individuals and the companies involved and what strategy you've picked and which direction you're going. Because honestly, I've done a lot of work with individual inventors that have a very, how should I put it, high expectation for what their licensing revenue stream should look like. And if it's one that's out of bounds with what is reality out there, I think you're going to end up in the courts. And on the other hand, I've worked with groups that are very reasonable. They understand exactly what it looks like. They know what the royalty stack looks like. They know what they can and what they can't get. And that is stuff that usually ends up into the arbitration and mediation. Maybe it doesn't even get into court. It ends up being a licensing discussion. It may take 6 months to be done, but it really kind of depends upon the individual. I'm not sure you can train that, I guess, but again, a lot of it boils down to money when it comes to licensing, and how much do you want and how much are you willing to pay.
And it's one thing charging, it's another thing collecting.
That's correct.
So, as we all know, as for those of us who, in law, you can say your rate is $900 an hour, and people might not pay that, but that's your rate. Which leads to some of our other panelists. Karen, you've been teaching for a long time in a variety of places, and most recently at FACOMP. How are we doing in terms of it's what I call law 4.0. We're very good, and what Guy just said about you didn't learn this stuff in school as an engineer, and lawyers are always brought in after the fact rather than before the fact in many disputes. What can we do to train our lawyers to be more client friendly? To maybe it's coding, maybe it's mediation, but the disruptive technologies of industry 4.0 need more than lawyers from the 19th century. And so how do we, or who are trained in 19th century legal doctrine, what can we do to make IP and the future IP better for everybody in terms of legal practice, but also on the ground realities for engineers and innovators?
Well, in my law school, we are discussing, of course, the kind of issues that we should bring, essays and so on. And in this calendar year, I'm teaching mediation, arbitration, and contracts, for example. And this is something that's very difficult because it used to arise in the last year of law school, and now it's coming in the earlier years, so that the mentality changes. It's not so adversarial, but also in terms of finding agreements and a culture of peace and so on. We are also focusing on data science skills for the lawyers, business intelligence skill related to the data science, and also design, how to deliver the legal services in a way that are more palatable or more nice for clients to receive and for non-lawyers to understand. In terms of IP, this is also an important topic that has been brought to law school. It was not always something that was taught. In recent years, it has gained more importance, not as an alternative thing that they choose, but something that's obligatory. And I think that's it. How practice will develop, it will show.
Thank you. JP, you get the last word. And you have a background in physics, if I recall, and then went to law school. Were you disappointed?
No, I just couldn't, the physics was getting too difficult for me, and I knew that I won't be too successful if I went down that career path.
So, but in law school, did you learn the stuff that you're doing now, or this is just by experience?
Yeah, no, in law school, and my first job is working in law firms. And when I was at law firm, I want everything to be litigation, right? Everything to be litigated. And so we would have work. But the arbitration mediation you mentioned is just from the experience. It's just you realize there are all these, and I think each one has their pros and advantages, and each one has a role. And I think arbitration, some cases, some issues, arbitration is the best way to do it. Now, some are mediation. Like at Samsung, we had number of patent issues, and a lot of them were resolved in our, not a lot, some arbitration, a lot in mediation, some in litigation.
And the latter being some super high profile expensive stuff as well.
Yeah.
Thank you all. We've had an amazing panel here at Digital Davos 2023, talking with our experts on the future of IP rights and IP law. Professor Dr. Karen Clem-Franco from Brazil, thank you so much. JP Hung from Qualcomm, welcome to San Diego, and thank you for participating. And all the way from Singapore, Guy Prolix, thank you so much for joining us. And unfortunately, Dr. Bashar Malkali had trouble logging on. He's from the United Arab Emirates. We wish him well, and we hope to have a chance to reprise this conversation another time. So I will leave you here. My name is Professor James Cooper from California Western School of Law here in San Diego. Thanks for joining us here at Digital Davos 2023. Thank you all to our panelists.